Law, Reason and Emotions, Part 2 of the presentation for the Recognize e-learning course. The first presentation was dedicated to the philosophical treatment of the relationship between reason and emotion. I have argued and tried to show that from antiquity to the modern era, a particular paradigm, which I call the standard conception, was universally accepted. This paradigm rests on two assumptions. One, reason and emotion, and similarly law and emotion, belong to intrinsically different spheres. And two, reason being superior to emotions, needs to manage and govern them. And by extension, so must law. Now, there is no immediate reason why we should identify law and reason. As I have briefly mentioned in the first presentation, there are numerous points of coherence or even of identification between law and emotions. But it is in telling that, at least in the history of Western legal culture, this identification of law and reason has been universally accepted as indisputable. The second presentation will explore how the twin presumptions I have just described have shaped our understanding of law and its operation. I will focus, without harboring any illusion that this overview is exhaustive, on three illustrations. First, I will briefly explore different conceptions of law. The examples will show the overwhelmingly the law that was treated as inherently rational, a domain of reason that by its very nature excludes emotions. Second, by analyzing the architecture of judicial proceedings, I will endeavor to bring to light the sustained efforts to exclude the emotional from the application of law, or at least to manage and control it. Finally, I will succinctly explore jurisprudential debate on the nature of judicial reasoning. Again, we will be able to observe the same standard conception in action, shaping our understanding of the delicate processes of judicial decision-making. This analysis will be an examination of the history of idea, but it will, I hope, bring to light certain features of our thinking about law and its application that will be far from obsolete. The implications of these features will be more fully explored in presentations by Micha Hafner and Christina Chufar. In my presentation, I will endeavor to show that the standard conception still informs law's everyday functioning. One additional observation: it is an interesting feature of discourse, both about law and of law, that emotions are seldom explicitly mentioned. If the philosophical reflections often contrapose emotions or passions to reason and discuss why the latter is superior to the former, emotions are rarely even mentioned in law. The dominant discourse passes over them in silence. We will therefore find numerous examples where different authors and scholars argue that law is by its nature inherently rational, but rarely contrasts that the law to emotions or argue that law should disregard emotions. On rare occasions where emotions are mentioned, they are often attributed to lay people, jury members, for example, or described as something to be avoided, as something threatening judicial impartiality. A specific self-perception of law as a practice and latter as scholarly discipline emerged quite early. The common sense observation that the law strives to introduce order and structure into human society has built on the idea that law has to constrain human passions, which would left to themselves introduce nothing but chaos and turmoil in human society. The law was perceived not only as something opposed to emotions, but also as something that had to overpower them. This process of making sense of law's purpose built on the common sense notions, but was at the time informed by philosophical reflection on the topic of passion and emotions. Quite often, the same philosophers who contemplated the relationship between reason and emotion in a more abstract way also tried to make sense of the law. Aristotle is a good example. In the previous presentation, we have seen his disdain for the emotional spheres of human soul. When he turns to law, it comes as no surprise that he tries it as the epitome of reason. In his discussion of the choice between the rule of law and the rule of men in the third book of his treatise, The Politics, he writes, "He who commands the law should rule may thus be regarded as commanding the god, and reason alone should rule. He would commands that a man should rule adds to the character of the beast. Appetite has the character." In all well-known passage, he defines law as reason free from all passion, and arguably sets the tone of the debate on the proper relation between reason and emotion in law for centuries to come. The law is to be understood as something purely rational, but this bold proclamation was difficult to square with the reality, where law was quite often embroidered in a sea of passions and far from being the embodiment of reason. An idealized vision of law was therefore needed. From the antiquity onwards, there is a latent dichotomy between the law as it is, so-called positive law, adopted by human lawgivers, and the law as it should be, the perfect or pure law. The human lawgiver must strive towards that can never be fully realized. This idea of law came to be described as natural law, which was eternal, immutable, and embodiment of perfect justice. It became a blueprint for how law should be. The idea of natural law quite naturally became a perfect vehicle for the idea of a fully rational law. This shift can perhaps be most clearly observed in Stoic philosophy, which expressed its idea of natural law with the concept of logos. Now, the Greek word logos has several meanings, but the most prominent and pertinent is reason. The main thrust of Stoic ethical teaching was therefore conveyed by a concept of a perfect reason that is not only pervading and animating the universe, but also comprises binding guidelines for all of us. Let me illustrate this with a fragment from an influential Stoic philosopher, Chrysippus. The fragment shows how the concept of reason and natural law became closely connected. The fusion of law and reason quickly became a central feature of thinking about law. This shift is important primarily because the Stoic philosophy was enormously influential. Not only was the Roman philosophy heavily influenced by Stoic concepts, it also influenced Christian and even Enlightenment philosophy. When Cicero discusses natural law, he does it in Stoic terms. His famous definition of natural law adopts a telling translation of Stoic logos, right reason. In his Republic, he writes, "True law is right reason in agreement with nature. It is of universal application, unchanging and everlasting. It summons to duty by its commands, and averts from wrongdoing by its prohibitions." Cicero's theory of natural law has proven to be extremely influential and was widely accepted through the Middle Ages. Without any ambition for a comprehensive overview, I would like to point out just a handful of examples how the idea of natural law was permeated with its reliance on the rationale. Take, for example, Aquinas' famous definition of natural law. He describes the elusive concept of as sharing in the eternal law by intelligent creatures, implying that the perception of natural law is somehow the exclusive function of the rational part of our soul. This emphasis grew even stronger in the modern era. Grotius, the father of international law, describes natural law as the dictate of right reason, and similarly, Hobbes and Locke put the notion of reason in the very center of natural law. As I have already mentioned, Hobbes sees passions as very center of natural law, inclining us towards a well-ordered society, but it is human reason which spells out the terms under which we will form such a society. These terms are what he calls natural law. Locke, in a similar fashion, sees reason as a necessary means to discover an articulate to do. Perhaps the most telling is the excerpt from the immensely influential Pufendorf's treatise on the law of nature and nations. The mind should take every care that it keeps its motions and affections in control, since most of them do not only entirely destroy the strength of the body and vigor of the mind, but becloud and distort the judgment of the intellect, and turn it with great force away from the path of duty and reason, so that the coldness of passions is, as it were, the natural source of prudence and prohibity among men. And adds an equal telling quote from Quintilian, Roman educator and rhetoricians: profound emotions pay no attention to law. These excerpts, I believe, paint a very compelling picture about the central position held by reason and philosophical treatment of law. If reason was central to natural law, and natural law is presumed to be the ideal towards all human law should strive, then it becomes clear that in Western legal imagination, law and reason are intimately connected. Even when some philosophers, Bentham is a good example, repudiate the idea of natural law, they still cling to the underlying idea of rationality. His utilitarian principle, which he proposed should become the ultimate guide for the legislator, is in essence an exercise in mathematics. The right course of action is to be determined by comparing the amount of pleasure and pain produced by the action. It was only in the beginning of the 20th century that emotions began to be taken seriously in legal theory. The pioneering role in that regards belonged to Polish legal philosopher Leon Petracci, who incorporated emotions in his psychological theory of law, arguing that legal phenomena consists of unique psychic processes. These psychic processes are set in motion by impulsions, which roughly correlate to emotions. The center of gravity in law shifts from observations of external phenomena to the minds of the individual. His theories remained largely unnoticed for a long time, and it is only in the last couple of decades that his contributions to the field of legal philosophy was recognized. Let us now proceed from the lofty consideration about the nature of law to the more mundane operation of law in everyday setting. It is perhaps here where we can most clearly observe how background assumptions about the detrimental effect of emotions shape everyday operation of law. Here, my focus will be mostly, but not exclusively, on modern court proceedings. First, contrary to many other legal cultures where disputes are resolved throughout meditation or negotiation, Western understanding is premised on the centrality of judicial decision making. The judge is supposed to merely apply pre existing norms to the dispute. She has to determine facts and law and apply the law to the facts at hand. Now, both discovery of relevant facts and determination of applicable law are generally understood as a process of gathering and understanding empirical data, which emotions would only distort. Acknowledging there can be different interpretations of law and facts, the judicial processes is structured in a confrontation of mutually exclusive narratives, which prepares the ground for rational evaluation of each account. The central figure in this process is a judge, whose defining characteristic is her disinterestedness. The most important impediments for a person to perform the office of the judge are not only direct personal benefits from her ruling, but also presence of strong emotions she may feel towards either party. Hobbes' description that a judge must be divested of all fear, anger, hatred, love, and compassion captures well the prevailing attitude, even 3 centuries after it was written. Any sign of hostility or ill will, as the European Court of Human Rights indicated in the case of De Kuber versus Belgium, would be grounds for recusal. So would be judges' goodwill and affection towards either side in a controversy. In a remarkable passage in one of his dissenting opinions, Justice Frankfurter, a Jew, captured this core tenet of judicial office, stating, "One who belongs to the most vilified and persecuted minority in history is not likely to be insensible to the freedoms guaranteed by our Constitution. Were my purely personal attitude relevant, I should wholeheartedly associate myself with the general libertine views in the court's opinion, representing as they do the thought and actions of a lifetime. But as judges, we are neither Jew nor Gentile, neither Catholic nor agnostic. We owe equal attachment to the Constitution and are equally bound by our judicial obligations, whether we derive our citizenship from the earliest or the latest immigrants to these shores." Emotional detachment is presented as a crucial trait of a good judge. It is interesting how this attitude is reinforced by judicial attire. Robes and sometimes wigs underscore judges' detachment. Even today, some judges describe the emotional effect of putting on a robe as stepping into a role distinct from themselves, and disassociating themselves from their emotional world. Finally, the more discreet aspect of judicial proceedings also promote rational approach to the decision making. Consider, for example, the strong preference for written submission to the court, thus limiting emotional effect of immediate personal appeal of litigants to the court, or the symmetric structure of the discourse in the courtroom, where each statement made or evidence presented by one party can be rebutted or challenged by the other. Quite often, parties are represented by professional lawyers, who are also expected to be dispassionate and removed from the tumult of the conflict. And finally, decisions take time, which allows for passion to cool down and rational deliberation to set in. Perhaps the most important arena where emotions enter into law is the domain of legal reasoning. I will refrain from analyzing the notion of focus only on the period of the 18th century onwards. I will leave it to Micha Chufar's presentation to elaborate on today's understanding of the interplay between emotional and legal reasoning. The reason for my focus is partly the absence of a more detailed theoretical analysis of legal reasoning and the scarcity of sources. But the main reason is a simple fact that contemporary understanding of legal reasoning was shaped in that exact period. I have in mind Montesquieu's enormously influential vision of division of powers. He argued that the authority of the state is to be moderated by separating three most important functions of the state: that of making laws, that of implementing them, and that of interpreting them. The first is the domain of legislation, the second, the domain of executive, and the third, the domain of judiciary. But most importantly for us, the task of the judge should be carefully circumscribed. Judges should not be allowed to make laws, but merely to interpret the law adopted by the legislative branch. Hence, his famous catchphrase that the judge should only be the mouth that pronounces the words of the law, and the concomitant view of the role of judiciary in general. This insistence on judicial passivity and detachment underscored the reasoned contemplation of the dispute judges are expected to provide and service as an antithesis to heated passion of the parties. Less than 2 decades later, Cesar Beccaria made the same impassioned argument for judges to interpret the law in strict accordance with the texts of the law. The model he offers for legal reasoning is one of pure logic, the syllogism. One of the main reasons for his insistence on the pronounced textualist interpretation is exactly the peril of intrusion of emotion in the domain of law. This outline, which soon became generally accepted, came with a host of background assumptions. The most important for us is that the legislative department is the scene of conflicting passion and emotions. Consider Montesquieu's jaded remarks that the law always conform to the passions and prejudice of legislators, and that the judicial branch is the place of dispassionate and serene application of law. Legal reasoning soon began to be compared to purely logical or even geometrical exercises. Savigny, one of the most influential German scholars in his lifetime and beyond, likened the application of law to solving a geometrical puzzle. Like a mathematician, a lawyer should proceed from the leading axioms and deduce the correct result. No wonder, then, that he himself described interpretation as calculation with notions. Legal reasoning is presented as thoroughly rational and thus autonomous, separated from everything that is not legal. Legal scholars hardly ever mentioned emotions. They did not need to. It was understood that by implications they are superfluous and should not enter into deliberative processes leading to a decision. This has become, as Terry Maroney has pointed out, the persistent cultural script of judicial dispassion. Interestingly, seldom are emotions explicitly mentioned. Few scholars articulate these commonly held assumptions explicitly. One telling example comes from a much cited article by Robert Leffler, where he offers some advice on drafting of judicial opinions. The approach should always be measured, temperate, and objective. Rhetoric is best suited for the advocate. An opinion expressed a decision above the individual passions in the case. Even those who are much more sympathetic to non rational factor influencing judicial decision making are wary about leaving human passions completely unbridled. Even Jerome Frank, the notorious American legal realist, did anything but advocate for emotions running wild. His hope was that by acknowledging her emotions, the judge would be able to control and rein them. In judicial opinions, the specter of passion or emotion is invoked as something that is to be avoided. In CSX Transport versus Hensley, the United States Supreme Court observed, the jury system is premised on the idea that rationality and careful regards for the court's instructions will confine and exclude jurors' raw emotion. Jurors routinely serve as impartial fact finders in cases that involve sensitive, even life and death matters. In those cases, as in all cases, juries are presumed to follow the court's instructions. In a different case, the same court commented on a possibility of setting aside a jury award by noting that it is not disputed that a jury award may not be upheld if it was the product of bias or passion, or if it was reached in proceedings lacking the basic elements of fundamental fairness. As you might have observed, the temptation of succumbing to emotion in reaching the decision is attributed to law people involved in the administration of justice. Community passions form a true challenge to the administration of justice. But emotional disturbance are hardly even attributed to judges who tend to think of themselves as beyond emotions. Jerome Frank, whom we have already mentioned, remarked in one of the judicial opinions, much harm is done by the myth that merely by putting on a black robe and taking the oath of office as a judge, a man ceases to be human and stripes himself from all predilections, becomes a passionless thinking machine. The role emotions should play in law can be disputed, but it can hardly be denied that emotions are present in law and that they affect its operation. In the following two presentations, various aspects of the interplay of law and emotions will be addressed. Christina Tschufar's presentations will highlight the ideological implications of the binary opposition between reason and emotion, and Michael Hafner's will elaborate how intertwined reason and emotion are in the context of legal decision making.